All right. One topic that we have touched on but haven't really been able to take a deep dive into is technology and big data. And thankfully, we have Ropes & Gray here as our sponsor today, and Mark Barnes, partner at Ropes & Gray, to talk to us about just that and sort of set us up for the rest of the discussions this afternoon. Mark advises clients throughout the higher education and healthcare industry, including pharmaceutical companies, biotechnology firms, and universities. He has extensive experience in a variety of legal fields related to stem cell and genetic research, research grants and contracts, and data privacy, to name only a few. Please join me in welcoming Mark to the stage. Thank you.
Great, thank you. Thanks very much, and welcome, everyone. I'm not a person who does value-based healthcare. That's not my thing. There are other people at Ropes & Gray who do it. What I do is I work in the research and development space, both for industry and also for academia. And as part of what I do for academia, including academic medical centers, I worry about data, about big data, about small data, and about all the laws, rules, regulations, and ethics codes that govern the use of data. And so the reason that I think I was asked to talk to you today is because data and the use of data analytics underlies so much of what might be done either as methods or as experiments in the course of value-based healthcare, and trying to understand how best to organize healthcare so that it does, in fact, yield value. So what I want to do about data is, I think all of you know about health services data, about claims data, about the data that are embedded in electronic medical records, and how those can be used together to understand patterns of care, outcomes, and everything else. So I'm not going to tell you about that. I want to sort of shock you a little bit and tell you about data data sets that are on the horizon and that you may not have thought about yet. So that's what the purpose of this is. And then I want to illustrate for you some of the ways in which there are both legal, regulatory, ethical hurdles to the use of any of these data, including, but not limited to, the claims data and others. So here are some things that you may not have thought about that are potential sources of data for calculations in value-based healthcare. One is the fact that we have in our universities and to a lesser extent in industry, in biomedical sciences, we have a movement toward open science. This has been accelerated when Harold Varmus was the head of NIH, and pushing for the idea that both preclinical data, that is bench science data, including animal research data, and human data, once the experiments have been done, once the analysis is complete, that those data down to the patient level, though anonymized, ought to be free and available for anyone to be able to use in order to be able to reproduce, in order to be able to reproduce the experiments, in order to be able to reproduce the analysis, in order to be able to check the analysis, and in order to be able to combine data sets that were already collected and do metadata analyses with these data. And in Harold Varmus's case, his theory was, and it still prevails, is that the federal government paid for this. These data belong to the American people, and they are to be exploited by anyone who can exploit them. So this is a movement that is well underway. Now, in the clinical trial context, which is where we get human health data, primarily, at least on the cutting edge, then there are other things that have gone on that are not caused by the open science movement, but they certainly are allied with it. One is that, you may not know this, but the European Medicines Agency, which is the equivalent in the European Union of the US FDA, actually has a policy put forward by its own director, Guido Rossi, that will be implemented in the next 1 or 2 years that will require that all industry players that submit an application for marketing approval to the EMA, whether the application is successful or not, are going to be required 6 months after approval or decision on the product. They're going to be required to post publicly all data points collected in the course of the clinical trials, down to the patient level, down to the blood pressure, down to the complete blood count, down to everything. These will all be publicly available on the web. And they will probably be curated by, some say the EMA, others say the companies will do it themselves. And then there are other things too. The International Committee of Medical Journal Editors is pushing the idea for open data for anything that they publish. They would like the data sets down to the patient level to be available to anyone to look at, check, and reuse if necessary. And then we have, in the background, we have a number of disease advocacy groups, including in the rare disease area, but not only in the rare disease area, that themselves have begun to compile registry studies, massive databases of people who are part of their own affinity group, both families as well as patients, and sharing those data, not necessarily publicly, there might be controlled access, but they are compiling these data and they are making these data sets available for use for research. And then we have genomics. And in genomics, we have, so it's not just phenotypic, it's not the traditional phenotypic and claims data. They're genomics data. There are NIH requirements that say that any institution in the US that gets money from the NIH in order to be able to do genomic sequencing is required on some level, either through controlled access or open access, to make all of those genomic data ultimately available. Incredible. You can imagine that researchers, in many cases, don't like it because it means that their proprietary interest in those data, once they have made their initial publications, one might say has been diluted. Again, disease advocacy groups, many of them are allied with Illumina and some other firms and are doing genomic sequencing in mass quantities of patients who are part of their disease advocacy groups, compiling massive databases. There are proprietary genomics databases. And we have companies like, and I'm not giving anything away because this has been announced publicly in many cases, Regeneron is saying to lots of hospital systems, including to Geisinger in Pennsylvania, if we will sequence all of your patients for free in return for our being able to have a license to use all of the genomics data and the associated phenotypic data. Now, this is a Regeneron database, presumably, but it's a huge database, and it's not just Regeneron that's doing it. Precision medicine, CAR-T therapies among them, require genomic sequencing, and all of those data are combined, compiled, and they become part of a medical record. And then finally, laboratory science, whether it's the methodology is through laboratory-developed tests, exception in enforcement discretion under the FDA, or whether it's actually to apply ultimately for FDA approval, or whether it's neither one and the startup company just wants to do it, regardless of what the regulatory pathway necessarily is. These laboratory startup companies, and many of them are actually not so much startups anymore, they're well-founded, they themselves are compiling massive databases in their quest for perfecting diagnostics based on genomic sequencing and trying to identify variants of known significance. So here's some other things. So there are some sources of data. Here's some other things. There's this exception under HIPAA, which has not often been used, but it allows business associates of two different covered entities that have no relationship to one another to take those data in an identifiable format and combine them and use them for quality assurance, for cost efficiency analyses, for all sorts of healthcare operations. This is allowable, but the commentary on it from the Office for Civil Rights is scant, but people have found it, and there are institutions and companies that are using it. Then there are some less savory sources of data. In my role as a lawyer at Ropes & Gray, I am often called in when there are data deals or one company is trying to buy another. I'm called in to look at the provenance of the data and to understand whether the data have been appropriately derived and are being appropriately used before the company with the data is bought or before those data are licensed. And there are some very ethical and legal practices out there for the provenance of data, but there also, I have found, unfortunately, a lot of situations in which there are boiler rooms of 100 people who are online pretending as though that they have a disease, agreeing to terms of use that they immediately violate online, and then pretending as though they have a disease, and then scraping, and then engaging in conversations and scraping the databases to derive either identifiable or important but non-identifiable information. And then there's algorithmic decision-making and AI, which is being deployed all over the place. And Natana talked about the deployment in Singapore, but it's not just Singapore. This is going on in India. It's going on in Nigeria. It's going on in places in which healthcare for the middle class and the upper class is paid for out of pocket. And so there are not these regulatory restraints that we have in all the silos, the ossified system that we have for reimbursement in the US. And then there's monitoring by cookies, there's monitoring by Fitbits, and there's monitoring by video and audio of real-time behavior, and all of those data about people who ultimately may be identifiable. Then what are the hurdles in all of this? One of the hurdles is that the refuge that we have all sought for many years is the thought that we can successfully anonymize data or de-identify data, depending on what your regulatory standards are. That has been true, but we know now from the work of Latanya Sweeney and others at Harvard, from some Israeli scientists and others, that in fact the idea that data can be de-identified was almost dead on arrival the day that the HIPAA regulations were first issued. Because there are so many databases that are either publicly or privately available that can be used to triangulate so that we can certainly narrow down and in many cases, perhaps even most, identify data to identifiable people. That's one obstacle, is that we don't have this refuge anymore, or it's receding in its availability. Then we have claims by individuals. We have rights claims that you've heard. I own my data, they say. I own my biospecimen. That's another variant of it. And therefore, you can't do anything with my data or my biospecimen unless I consent to it or unless you pay me for it. And you know, there even are some firms that you can sign up for on the web that allow you to sell your data for a few pennies. But you can get a few pennies for it. So the US government, in regulatory issuance about 18 months ago, came up with the idea that people could be asked to give their broad consent, not because they own their data, but because they have some rights to control their data. This has yet to be worked out. The thought of broad consent in human research for data research has been largely dead on arrival because of the poor way in which these regulations were drafted. And then when one uses big data, here's another hurdle. When you use big data and you're trying to do it in a way that will either derive or identify diagnostic or prognostic indicators or even indicators for treatment, then what do you do when you find something? If you do it by design, do you tell the patients and the physicians and the data subjects? Or maybe you find it incidentally. And so then what do you do with the results? What I tell our clients who are doing this is, you better make a plan before you start in regard to whether you're going to return the results, to whom, and in what situations, because otherwise you will be in bad shape. And then there's the question, legally, what's the range of permissible uses of all the data that you have acquired? Certainly, you know, there are pathways, regulatory pathways to use data for utilization review, QA, predictive economics, search for systems efficiencies, and other things. These are allowed as healthcare operations, at least within covered entities under HIPAA in the US. But in general, other than this pathway of allowing a business associate to share identifiable data and perform data aggregation services and analytics on behalf of one or more covered entities, there generally is not a good way to share these data, at least identifiable data, among covered entities for quality assurance and other kinds of purposes. This is a problem, unless the data are anonymized, and we'll get back to that in a second. Can you use these data to market healthcare products? Can you use the data to market other products that have nothing to do with healthcare, like cars, or electric cars, or anything else? And then there's the issue of social credit scores. When I talk about this, I'm not talking about government use of social credit scores in the way that big data are being used in China in an increasing way, actually to give access to public benefits and citizen rights, depending on how cooperative you are with the regime and how much you are viewed as, according to all the analytics the data that are available and the analytics applied, the extent to which you are deemed to be a good and constructive citizen. I'm talking about the use of these data for things like determining credit scores, credit worthiness, whether one should pay a higher price online for a product or a lower price online. These are all things that are potentially in play. And then, of course, monetizing data through data sales and licensing. So, in this case, there is something else. We talk about the US because the healthcare, because of our reimbursement system, is notoriously focused only on the US. And we are an island in some ways in regard to our health data and also the generation of health data through our existing reimbursement systems, both public and private. But we're not alone. We've talked about, and Natana Sharma talked about, and others have talked about today, other countries and their uses, their generation of data and their uses of data. A bigger economy than the US is that of the 28 members, soon 27 perhaps, of the European Union. That's a larger economy put together than our own, and they have a new data regulation which actually is applies to many more data than the US scheme under HIPAA. It applies to almost all data except family gossip. Literally. It even applies to what churches say about their congregants. It applies to everything. It applies to what you purchase, what kind of toothpaste you purchase at the drugstore or grocery store. And secondary uses to which we're accustomed in the US are actually very much narrower under the EU GDPR. We don't have time to go into it. But I can tell you that the reuse of data for secondary use purposes is more difficult under the GDPR. And it's much more difficult because the GDPR defines all health data, all race, ethnicity, and religion, and political affiliation, and trade union membership data as being sensitive personal data for which the secondary processing is much, much more restricted than it is in the US. Under the EU GDPR, people have a right to access their data, to understand how their data are processed and by whom, to whom their data are given, and they have the so-called right to be forgotten if there's no reason for the individual entity to have a legal basis to retain and continue to use their personal data. And this is not just in Europe, because in Brazil, there has just been, for example, a new national privacy law that has been passed, which is very similar to the GDPR model. It is not our model. It is not a sector-specific model, and it contains many of the same rights. Then, of course, in California, you have this act that's going into effect, presumably in 2020, although more limited than the GDPR, in many cases tracks some of these requirements. And so the international data exchanges and also the use of data that are pulled out of Europe are part of the hurdles here that we have. And so to conclude, what we have here is we have two worlds in collision. We have, on the one hand, in the promulgation, the proliferation of big data, and the uses of big data, we have the idea that there should be great transparency, that big data will save money, that they should be used, they should be deployed, and that they should bring good and profit. And there's nothing wrong with that. So there is that theory. On the other hand, at the same time, we have the push toward privacy, with people saying that they own their data, that they want to control their data, that they want to know to whom their data have been given, and they want to be able to restrict the uses, the downstream uses of their data. You can't have it both ways. You can't have perfect transparency and perfect privacy rights, that is, perfect data use and perfect privacy rights at the same time. And the background of all of this, and that is that lurking in the background is the idea that de-identification in short order is not going to be available as a safe harbor for us to be able to try to reconcile these two forces. What I give you here is a castle in the sea off the Isle of Man, which the EU is designated to be an EU GDPR compliant jurisdiction. But indeed, our castle stands now, but the sturdiness of it is certainly in question. So I will stop there, and thank you for your time.
Great. Thank you so much, Mark. That was fantastic. Before we move on to a quick networking break, I just wanted to highlight another Bloomberg Law event happening here in San Francisco on June 20th. The In-House Forum West is one of a series of events sponsored and hosted by Bloomberg Law, and it is a full-day event designed specifically for in-house counsel, where industry leaders will come and share their best practices for managing both internal and external investigations. And so if that is of interest to you, there's more information at the registration table, and you can actually register it for it today. So we'll take a quick networking break, and if you need CLE credits, be sure to sign in and out of those at the registration desk. And feel free to continue chatting amongst yourselves and keep using our hashtag. And we'll see you back here at 4 o'clock. Thank you.